And I appreciate your concern. It's a valid concern because I'm hearing through the grapevine about appraisal management companies asking appraisers if you've ever had a complaint filed against you. And if you answer truthfully and the answer is yes, then you're not getting on the list. I personally, if I didn't say this before, my remarks reflect my opinions, not necessarily the opinions of the subcommittee. But personally, I think that that's not right. Anybody can have a complaint filed against you. That is in no way an indication of innocence or guilt. It's a great way to take out your competition if you think that every complaint is going to get that person or that company removed from other people's approved lists. So that is a problem that's out there. But from the subcommittee standpoint, nobody is going to get any information from us in regard to a complaint being filed against an individual or a company. We're not taking the complaint. And a complaint is, like a lot of things, it has its own definition in each state. So for USPAP complaints that go through us, those will, the way it's designed right now at least, those will all go to the states. And then they enter the state's complaint system, and they have to go through the process and the state will go through the process to determine whether it's really a valid complaint or not.
Okay, thank you.
I just wanted to piggyback on what you were saying and what your personal opinion was there. And, you know, one of the reasons why the AMCs are sitting there saying, have you ever had a previous complaint, is because Fannie Mae themselves are dictating to the AMCs, and they're saying we will not accept any appraisal that was done by an appraiser who has a previous complaint. So since FHFA falls under, you know, with the ASC and there, maybe there's an opportunity here to reach out through FHFA to put the pressure on Fannie Mae to eliminate that position, which would then allow AMCs and larger appraisal companies to be able to use an appraiser who may have had a previous sanction. Because let's face it, you did something wrong, you know, 10 years ago, and you took your education course and you're back in good standing. There's no reason why you can't, we can't accept those appraisal reports.
Well, just to be clear, there's two concepts here that are real important to distinguish: complaint versus sanction. And if Fannie Mae, Fannie or Freddie have any kind of rule or guideline against using an appraiser that's had a complaint filed against them, please send it to me. I don't think that that's the case. I think it's if they've had a sanction that there might be an issue. So it's very, particularly with this hotline coming on board, it's important for people to understand the difference between a complaint and a sanction. A sanction, obviously, you've gone through a due process procedure, whereas anybody can file a complaint against anybody. That shouldn't give anybody any that doesn't give any indication of guilt or innocence.
Yeah, I was mainly referring to sanction. If I use a complaint,
Okay.
my wrong choice of words on my end.
Thanks.
Okay. You know, in the recent past, in the last 10 years, I had an issue with a particular stockbroker. And he worked for a major stock brokerage company, but what was happening to myself and a group of people that he had as clients, they got pretty much wiped out. So I decided to do some research, and there was remedy for us to research his background and found out that he had a gang of complaints against him. And we took him to task for it and got our money back. But so what I'm really saying is the appraisers aren't the lone rangers in this issue. There are other things like stockbrokers. I only know stockbrokers where you can look them up and see what their record is. And I just wanted to bring that to your attention too.
Sure. Appraisers are not the only ones who have gotten additional regulation out of the financial crisis we're still in. Mortgage brokers, loan officers now have to be licensed as a result of the SAFE Act. In order to be a broker or any type of loan originator, you now have to take education, you have to pass an examination. There's a list, a national registry, if you will, called the National Mortgage Licensing System, NMLS, that brokers, originators have to be on. So yeah, we've gotten a lot more regulation out of the crisis we just went through. We're still going through.
We have time for one more question due to travel arrangements. And
In Oregon, our ACLB is semi-independent, and we have legislators who are seeking to take that away legislatively. If that happens, it goes into, the ACLB goes back under total government control, goes under, what is it, the DCBS goes back, and it's total control. What they're going to do is sweep the budget that we have. At this moment, we are independent and we don't cost anybody anything except the appraisers. So if that happens, semi-independent goes away, our board diminishes, we can't keep up, and so can you drill down a little bit, a little more on that as how you would handle that if all of a sudden we're not getting stellar reviews anymore? Does that make sense?
Yeah, the subcommittee doesn't have the authority to tell states exactly how to set up their program. In guidance, we tell the states that their program should be independent, but if they're part of a greater umbrella agency, like you're talking about, that's okay. There still needs to be lines of independence. So for example, to make sure that if you're under the real estate commission or something like that, that there's not pressure being foisted from the real estate agents on appraisers or the appraisal program that would be contrary to Title 11. But the real bottom line for us is once every 2 years, more frequently if you've got a program that's got some issues, we come in and do a compliance review. We check to see if there's 7 areas that we review of the state program. We check to see if you're in compliance or not. If you are, you are, and if you're not, you're not. And as I talked about earlier, states are going to get a more specific indication now of the health of their program as opposed to just being in insubstantial compliance, not in substantial compliance, which are so broad. It's up to the state to follow Title 11. If they don't, we will let them know.